Thank you for watching the World Community Magazine's Hour of Power Live on Facebook with your host Edward McQueen and April Garner Davis.
Wow, these things happen sometimes. I'm glad we're live. Anyway, so our apologies to all of our viewers. Everybody has technical difficulties ever so often. But we have some experts over here. We do our best. So, good afternoon to you, April.
Good afternoon. How are you?
Very well, very well, very well. April, we're going to get right into this today as we were promoting the fact that it was concerns from the community about, just a lack of knowledge on the law. And so in the interest of community concerns, we just want to make sure that our community is not behind the eight ball when it starts coming to these things of dealing with the law, and that these things happen. So when you need legal advice and everything. So we want to start a series called Understanding the Law, and we don't know how it's going to go, but we want to continue to have legal representatives, if not a lawyer, someone who's well versed in the law, to come and just give it their different perspectives and join discussions, and so that our commenters, we can get good comments from people who want to know just something about the general law. Okay. So intent is to have a number of different lawyers, like I said, from the community and beyond. Having said that, we would like to, we thought we'd start off with some local, well-known lawyers from the community, and Mr. Winston McIver Sr., who is a partner with the McIver Graham Law Firm in Conway, South Carolina. Been in Conway for a while. I'll let him tell you the number of years that they've been in business in Conway, but obviously must have been serving quite well, and must have been representing people to a great distance. So, without any further ado, let's begin with Mr. McIver, Mr. Winston D. McIver Sr. The name McIver in Conway is well known, I guess, with Dr. McIver also. The son of, and he's Winston McIver Jr.
Junior McIver.
Yeah, Junior. So you call him Junior.
And then Leslie McIver was here before me.
Yeah, right. That's right. Yeah.
Yes.
Yeah. Now he was really well known for a certain generation anyway.
Great band leader.
Yeah, absolutely. So welcome to the program, and I know you can engage in a good discussion and to kind of give us a well versed knowledge of the law in general. I know. Well, hopefully we have some comments from people who have just not just concerns, but who just want to know some knowledge about the law. All these things I think are very important and I'd say profitable to some people, especially since they're getting some free advice. It probably end up being that way. So Mr. McIver, not everyone has probably used your firm, but if you can, what we'd like to start off with is just to give us a general overview of what your firm deals with in terms of any other legal issues in Horry County and beyond, I assume. So, and you can. One thing I'd like to know is how long you guys have been in business. So, on you.
I think it's 46 years, if I'm not mistaken.
Right in Conway.
Yeah, maybe one or 2 years in Charleston. I did start with neighborhood legal services in Charleston, but
right.
The bulk of my practice has been here in Conway. We have 3 lawyers in our firm. George Graham, who's a my leg, my right hand, is one of the major partners. Myself and Angela Graham McIver. She's my son's wife, and she's a great lawyer. She's been practicing about 20 years, I do believe. What we have is what we call a general, basically a general law firm. We don't specialize in any particular area of the law, but we can handle them all. Except bankruptcy, we don't bother with bankruptcy. That's kind of by the books. You can do that. You can pick that up and do it, but we don't do that very much at all, really, to be honest. I have done bankruptcies in the past, but that was a long time ago. What we deal with wholeheartedly at McIver and Graham are certain areas, the major areas of the law, which I start with personal injury because I love personal injury and workers' compensation laws. Personal injury, of course, were car accidents, but in any other thing that you happen and somebody else is responsible for that, and you have damages, injuries as a result of what has happened. Basically, people think about car accidents, and that's the bulk of personal injury, but there are other areas. We've been getting a lot of slip and fall cases lately, and I have dealt with slip and fall. That's when you're in a business and the business does not keep itself up to date, in good standards, what should be done and what should be set for customers. I mean, you owe your customers a certain duty, and once you breach that duty, then they have a cause of action. You got to have with civil law that there are two areas, basic areas of the law. The other area is criminal law. I'll talk about that a little bit. We don't do a lot of criminal law, but we have to, we have to be a full service law firm. So we do a minute amount of criminal law. Criminal law, of course, is when you're accused of breaking the law. There's so many laws on the book, you'll have to read them yourself in the statutes. But you would have to have a warrant, generally a warrant, some type of warrant served on you for criminal law, in criminal law. But there's a procedure there that we can go through. We don't go through it too often. Back to the other side is, of course, civil law, civil activities, and that's where you get into maybe filing lawsuits if you can't work out a settlement. Generally, car accidents, slip and falls, any kind of act. If you get shot with somebody shoots you, it's just a wide open, a whole panoply of things under civil law. I can't get into them, but if somebody will do wrong, civil wrong is what it comes down to, a civil wrong, and there are damages as a result of civil wrong. Sometimes these cases can be worked out without a lawsuit. Well, most of the time, to be honest with you, 95% of civil wrongs are worked out, at least through our office. Every now and then you have to file a lawsuit, but we try to stay away from lawsuits as much as we can and work them out, make sure the client gets satisfied, or try to get the client satisfied. Like they told me in law school, nobody's ever satisfied. We do the same, but you do it to the best of your ability and to your client's satisfaction and as to what the opposing party wishes to pay. Generally, you go after somebody that has insurance. It's not it wouldn't be Walmart that has to pay, but Walmart's insurance company, and they have great insurance. They have a lot of insurance. If you slip and fall and break your arm or leg in there because of some thing that they didn't do, didn't live up to the standards of what the store should have. But they all are insured, so you don't feel sorry for them. All these companies that have insurance, and the insurance companies certainly don't want. They try not to pay you anything, but sometimes you have to file a lawsuit and get into civil court with them. Um, Also, on the civil side, we do what is called workers' compensation cases. That is, if you're hurt on your job, there's a certain set of laws that is clearly statutory that you could take a client through to get those cases settled or have them tried before the Workers' Compensation Commission in Columbia. 95% of those are settled somewhere down the line. The insurance companies do not want to try cases, and we try not to have to try cases either because it's a large expense. There are things that you have to do and pay for, and your client's final settlement will be cut because of that. So we try to stay away from that as much as possible. Every now and then we have to go to full route with that. Workers' comp and basic civil wrongs are what I do a lot of personally. Angela does a lot of, well, she does all of our domestic wing of the office. And when we talk about domestics, we're of course talking about divorces, we're talking about custody, we're talking about adoptions, we're talking about name changes, that goes only through the domestic court. There's a separate court, of course, set up for those actions called the domestic court. Of course, I have done them for a long time when I first started, so I'm very familiar with what to do and how to do. But Angela's doing an excellent job on that now through our office. Probate court, probate files are wills basically, and there are two ways you can get property after a death. We wholeheartedly encourage everybody to get a will. I've come into a couple of things that I knew were going to happen, and they happened because folks would not do a will. They would not execute a will. And I have a lady telling me she doesn't understand what's going on. Your property devolves to what is called intestate succession. If you don't have a will and you got property, you die leaving property, it has to go through probate court, and it has to go as the laws are set up in South Carolina. You lose control. The laws of South Carolina come into play. Now, true, you deal with family members, close family members and so forth, but that can get rotten. Trust me, I'm in the middle of one right now. It can get rotten. So it's best to get a will. We advise people, we're just not blowing smoke. We say you should have a will. Otherwise, it's going to go the way to go. Other ways
that you can ensure people, especially people who don't have any knowledge about a will or how important a will is. It is very, very important for those of us who know. How can you ensure them that it's not terribly expensive, and in most cases it's simple? Am I correct about that?
Yeah, you're correct. We do simple wills. Most people, I guess 50% of the wills are simple wills.
Right.
But that means a lot. If you're saying, I will all of my property to John Doe and Richard Rowe, maybe, it's simple. That's a simple will. Everything you got then can be taken through the probate court under the guise of that will. Folks that don't do that, it goes by the laws of the intestate succession laws of South Carolina, which controls, you know. And I have a lady that just can't understand what you talking about, you know. In the probate court, we got everything set and ready to go. But she's saying that they didn't work, they didn't do anything to accumulate this property. That doesn't matter. It doesn't matter if you without a will. It goes to the closest of kin. But I've seen some knockdown, drag out battles between close kin. So it doesn't always work smoothly that way. So we advise, and y'all should advise everybody to get a will. Now, there are a lot of these people coming on TV. We could do your will for blank, blank, and blank, blank, just send blank, blank money to us. I wouldn't trust that. I'd have a lawyer. Every state is different. That's what you got to know, too. So these people from New York telling you South Carolina, we could do your will for you. Maybe, but I wouldn't trust that. I wouldn't trust that. South Carolina laws are different from New York laws. Virginia, every state is different. In South Carolina, we require two witnesses. It used to be 3 witnesses, but the legislation changed that. It's now 2 witnesses. And you should deal out all of your property, and if you got a quirk about some property that you don't quite know, what you want to do with it, you can do a residual, what we call a residuary clause. That's anything that's left hanging that didn't go to the devotees in the will. Because you said, I will my Cadillac to John Doe, I will my 90 acres of land to Richard Rowe. And then if anything is left out, you got property, maybe you gain property. And this is kind of, doesn't happen too often, but if you gain some property 10 days before you die, the residuary clause would cover that. That's everything, anything extra that's not taken care of will go through that clause, and to whom you wish it to go to. You have to name somebody as your residuary beneficiary. But a properly drawn will should take care of everything. And if you only have a house, I know some people say, well, all I got is that old house over there, but you need to do a will on that too.
You mean do a will that includes the house? You're saying? You mean?
Excuse me?
When you say do a will on that, you mean do the will, but that includes the house also?
Yeah, but I'm saying people say, I don't have nothing much. Why do I need a will? You know, that's the question. Wills, we work with folks on wills. We don't charge $1 million for a will. You know, anywhere from, I'd say from $500 to $1,000, depending on what you want and how you want to do it. If you got 9 or 10 beneficiaries you want to list on the will, that's going to be a little bit more, you know, but you generally shouldn't get out of the range of $1,000, at least $1,500. Let me say that. I don't know. Shouldn't be much more than that. Unless you've got an really extensive will with 900 people you want to will stuff to, then it gets more than that. But a general simple will is in that range from our office. Now I can't speak for anybody else, but in South Carolina, I think that's the general cost for a simple will, between $500 and $1,500. But I'd spend them. It's worth it. It's worth it rather than letting any property go through the intestate succession laws of South Carolina. We do in probate court. We can do. We set up. But we set up estates, probate estates. I don't think I touched on that, but that's after a will, after a person passes,
Right.
the will has to be put through the probate court for it to be honored. And there's a procedure that takes about 8 months to get through. Generally, it's going to probably take a little longer than that, but the statutes say at least 8 to 9 months. And there's certain procedures you got to go through that you need an attorney to go through. I've seen quite a few people go there and try to probate their own will. And next thing you know, they're in our office saying, I need help with this, because the probate court is not going to help you probate a will. That's on you. And I would suggest a lawyer. I don't know what a lawyer would charge you, but I think if it's a substantial estate, you should get an attorney to handle it for you. Anyone out there.
Attorney McIver?
Yes, ma'am.
Hey, you're giving us some great information, and we have a number of questions and comments that have come from the audience. Can I kind of pivot over to that, and then we can see what comments or questions they have you may be able to answer? Is that okay?
You sure can.
All right. Awesome. Okay, awesome. So Priscilla Fuller asks, well, she said, sometimes after a monetary settlement, people are taken advantage of by unsavory companies that offer to lend monies for a certain percentage. How would you advise clients to safeguard not being taken advantage of? So how do you safeguard? He said, don't do it.
Don't do it. A lot of crooks out there. I mean, I think I'm understanding her question, but I wouldn't advise anybody to get involved with that. I mean, I know some people get to an extent where they just got to do something. They just got to do this. But there are more cliques out there than there are people who are going to really treat you right. How would you advise clients to safeguard not being taken? Yeah. You gotta actually know what you're doing. You know, there's too many games out there, and if you can stay away from it, do that. If you can deal with an established bank or credit company, then do that. But I don't know about unsavory companies. Yeah, there are a lot of them.
And so I will even kind of extend her question to ask, if someone is a victim of this type of a practice, do they have a legal leg to stand on?
Well, they can
as far as suing the company, or yeah.
Yeah, you know, if you've got legal reasoning, if you've been severely duped, there's been some manipulation of the laws, you need to talk to a lawyer on that, I would say. Because there are certain things you can do, but the problem with that situation in a lot of instances, now I don't know all of them, they're fly-by-night doggone companies. They're here today and gone tomorrow. You know, who are they? Are they established? That's why I say you need to try to deal with an established company, established bank, or something of that nature, because everybody is not going to do right. It just isn't. I've seen it happen over the years. Please, I wish I could help some people sometimes, but you just can't. Why did you do this? Why? But I thought so and so and so. But you see, it ain't that way. You know, try to deal with established companies who have reputations and have, you know, and you can talk to some other people who maybe dealt with them before, but this jump up overnight such stuff, I don't advise that at all, you know.
Okay. Well, we have another question from Timothy McRae. He wants to know a little bit about trust. What about a trust? Can you give us any information on what to do to establish a trust?
Trusts are good. You could establish them what we call an inter vivos trust, and you just go, get a bank, an established bank, and they've got trust departments, and you can set up a trust and contribute to that trust. Long to build it up. That's what you need to do with a trust. If you just got a whole bunch of money you want to put in a trust, go to an established bank and set up an inter vivos trust. What you do is set it up, and you need to set up a beneficiary. The bank's going to want someone to be a beneficiary. And that could cost a loved one or somebody that you want to help. A college fund later on down the road, or you just want to build on the trust yourself. That's called inter vivos. You're living and setting this trust up. The bank would be the trustee, and then you'd establish a beneficiary who it's to go to, and how you're going to deal with the trust. There should be a trust document filed with what we call the bank. The settlor sets it up and write it up how it's to be disposed of, or how it's to be used. You understand what I'm saying? That should be an agreement. Any established bank would carry you down that road, or we've done inter vivos trusts. It's not much to it. It sounds big and it sounds like something you got to have $1 million to do, but not necessarily. It's just a matter of the documents. Okay.
Here's another good question to follow up with that, and I was going to actually ask this as well. Timothy McCray also says or asks, can you put your home inside the trust? Is it better than a will? So is there a big difference between a trust and a will? And can you put a home in it as an example?
In a trust?
Mm-hmm.
Is that the question? Yeah.
Yeah, the question is, can you put a home inside the trust?
Your deeds, it would be through your deed. If you got it, if you own it, you could set it up in a trust, some type of trust, and execute the documents how you want it to be disposed of at that point in time.
And he's asking, is a trust better than a will?
Well, that's a good question. I would say it depends on, it depends on what you think and who you're trying to set up as the beneficiary, or what you're trying to set up the beneficiary as. I go along with wills, but that doesn't make it, the best thing. You have to take that on a case by case. I think it's situation by situation to say whether it's the best for you or best for John Doe or best for Richard Rowe. I don't think there's one all-out exclamation that it's better to do that, in my opinion. Okay.
Mm-hmm. Mm-hmm. Okay. All right. So we do have some other questions. Carolyn Hickman Williams asks, what is the process of having a name change for a child under the age of 1 in South Carolina?
You have to go to family court as a procedure. You get the child named as an action. You have to file an action with the family court to do that, and have a guardian ad litem set up for the child. That's an attorney who has no, I guess we say no flock in the game. In other words, the child has to have its own attorney separate from your attorney, but there's an action you'd have to file in court. We used to do a lot of them, but to get the child's name, but that's through the family court, and the family court judge will make a determination and have the name changed to the state.
Okay, child has to have a guardian ad litem, and then you can file. Okay.
Yeah,
All right.
you need a lawyer. You need a lawyer, and lawyers. The court's gonna require a guardian ad litem. That's a lawyer just for the child.
For the child.
But you know how that goes. So, but the guardian has to make a recommendation and stuff. So it can't be a flim flam thing, you know. But yeah, there has to be a lawyer for the child, and that lawyer has to, you know.
All right.
Get a court. You're seeking a court order from the judge with competent jurisdiction. Okay.
Okay. All right. Attorney McIver, there's a couple more questions. Obviously, there's these questions aren't all leaning into one topic, so just want to. Yeah, and I think it's great, that they're asking different types of questions, kind of leaning into your expertise. So Priscilla Fuller asks, for some of our young people with records as a result of legal violations, what kind of cases can this information be removed from their records? What is the process? So it sounds like she's asking, can the records be expunged or can information be removed?
Expungement. There's a procedure called expungement. Yeah, there's a procedure, statutory, and you need to get a lawyer to do this. We've done this before a long time ago. I haven't done it recently, but there's an expungement procedure to expunge the record. Okay, can be removed. Yeah. It's called expungement. That's what it is. But it's a statutory procedure that has to be complied with. And get a court order of expungement of the record from the circuit court.
Okay. All right. And then we have another one. Vonda Cookie Vandross Brown, thank you for watching from Columbia. Question. If you have personal property under $10,000, should you get a will? Because there's something you can acquire from the courthouse that is temporary control. She says she can't think of the name, but the essence of this question is if you have personal property under $10,000, should you get a will?
Well,
it sounds like she's trying to apply value to.
I would do, I think she's getting at, well, there's a small claims. If you've got under $25,000 worth of property, you could do a small claims thing without necessarily having a will. You can go to the courthouse and they have documents whereby you could access a minor league probate on that. If that's the question she's asking, I believe. Under 25,000. Under 25,000.
Under 25,000. Rhonda, if you have any other details that you want to add to this, but yeah, my interpretation is she's trying to figure out whether or not it's worth it, I guess, to have a will if you have personal property under $10,000.
I understand that, and it may not be if that's all she's got. Because she could get that through probate court through the small claims procedure over there.
Okay.
Any estate under $25,000.
All right. So those are all the questions we have so far.
Bunch of them on the line up here. I've got April. I've got Mr. Lee Moultrie from Charleston, and he can't seem to communicate on the Facebook pages. So he sent me a text and asked the question, said, how do we eliminate qualified immunity against police officers to protect all citizens? Is that under your umbrella?
Well, the legislature has to do that.
Okay.
You need to lobby your legislators. Okay. And they're not going. That's been a tough one for a long time. So I don't know. I guess you have to get groups to lobby, enough lobbying. Maybe we'll change that because it should be changed. It should be. I mean, this policeman just killed a woman the other day up in Ohio somewhere. She called for services. He went in the house and shot her at some point. I don't know. But they're just they're immune just by virtue of being a police officer. I think it's bad. I think there should be some knock on qualified immunity, if not completely vanished, you know. That's a good question. Need to work at it. Lobby for it. It's going to be hard to move, though.
It's going to be hard in South Carolina.
Yeah, it will be state by state. Yeah, it's a state. Would be a state referendum.
Can I just get back to the small claims, like you were espousing on earlier? Now, in some cities, I know a couple of the cities that I've resided in, they have what they call a separate court, which is a small claims court. Does that exist in Horry County, or you just have to go through the normal court?
No, we have small claims courts. The magistrate court is a small claims court.
Okay.
You heard the magistrate? I know you. That's a small claims court.
Yeah,
really it is. Okay. And it's a pretty good system in South Carolina. I might as well say that. Yeah, small claims are small things that you don't want to jump in the big court with. Probably don't have really the elements to get into big court with. I mean. But the magistrate courts, we got a good magistrate court system, a pretty good magistrate court system.
Yeah.
Do several things. Yeah. And say here, I'm talking about South Carolina. I can't speak for North Carolina or Virginia like that.
Right.
Okay.
Attorney McIver, there is another comment that's come in, and I'm going to try to paraphrase what's being asked. But basically, is there a time limit for processing things once someone passes away?
And when you're saying processing things,
the rest of the comment leans into the idea that the person who passed away does not have a will.
Okay.
And so is there a time limit for processing things once someone passes away who does not have a will? And there's two parts to this comment. The second part of it is the person is trying to reference something that gives temporary control for about 60 to 90 days to the survivors in the event that there was no will. Is there anything in place like that?
Well, they can file. Yeah, they can file with the probate court some type of action. I guess under the element of the small claims court. But now, if they have property, do they have real estate? I wonder, is that in the equation? You don't know?
I don't know. This same person mentioned earlier the personal property that's valued under $10,000. But when it comes down to probate, is there a time limit for entering into probate? Is there 5 years, 10 years? When is it essential for someone to enter into probate? As soon as someone dies, or do they have a certain time limit that they have to enter into probate?
Yeah, they should do it as soon as possible. But now, as far as you're asking me, is there a statute of limitation on that side? Real property, land, if that's in the equation, you got 10 years to do something on that. If not, then you have to do what we do a lot of, doing as property lawsuit to determine the heirs and determine who gets the property. A lot of people have died and they own property, never did anything about it, never dispensed of it. And if 10 years pass, then they have to do a lawsuit. And we bring that under Clementi Pinckney, the Clementi Pinckney Act in the statutes. That's a procedure based on that act that's been named after Clementi Pinckney. And that procedure we do a lot of, especially Black folks who got property hanging out there. Heirs property, in other words. You've heard that term, heirs property.
Mm-hmm.
But, you know, if heirs can get together within that 10-year period and divide the property up, there's no need for a lawsuit. But so much property has been left untouched for years. And it's a lot of us. You have to file a lawsuit after 10 years. If the owner, the landowner, if it's in his name, if it's in John Doe Jr.'s name, you have to get that together through probate court, or after 10 years, you have to file a lawsuit. And now we term it under the Clementi Pinckney Act in the South Carolina state statutes.
So the lawsuit would entail what, basically? I mean, what would it? Give me.
That's a good question. We have to gather the heirs, and that's the tough part of the job. Gather the heirs, who the heirs are. We have to deal a lot with obituaries and testimony. And testimony from some. Hopefully, there's an heir, somebody who can tell who lived here, who died, and blank, 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 and who were the heirs, who John Doe's heirs. They all may be dead, but then we have to go through those heirs to get to the living heirs who's responsible now as an heir. And that's kind of tough. That's kind of tough. But that's what has to be done, and a lawsuit has to be filed. And it can be a little bit expensive, but you have to get a judge to say that, you know, we put together enough information through trees. We set up trees, family trees, and we use, like I said, and going back, we use obituaries, and hopefully there's an heir that can tell us who was so-and-so's son or so-and-so's grandson. It's a large technical piece of work, but, you know, we do it every day, just about.
Attorney McIver, what happens when you have obituaries where people have been added that are not related to the loved one? What are the legal implications of doing something like that? Adding people to an obituary they're not related to you.
You took my question.
Yeah, that's a problem. That creates a problem. You know, we took care of Joanne Myers and our name doesn't mean anything, I'm sorry. We took care of her, and she's listed as an heir, but she's not a bloodline. She's not a bloodline. And we have to try to decipher that by question and investigation and so forth. Even requiring birth certificates and stuff like that. So it can be a tough job. It can really be and that's a good question, because that happens quite frequently.
So is it best to keep people's names off in most cases, or because a lot of people don't know that. They don't know the ramifications of adding a name, and they just want to make sure that they're part of that family and so forth, or, you know, just to be seen. But
yeah.
You know what I mean?
I don't know exactly how you deal with that, but it's best not to put them on that. Now, I can't tell everybody that, but you know, you add them, and you may not ever need that situation, but if you do, it creates some problems, a few problems. Because sometimes you have to just, if they're on the obituary, you have to add them you have to sue them too, you know, and get the truth somewhere down the line, hopefully. but they have to, that just add to your list of people you got to sue and the money you got to pay to have them served. And in the paper, we have to file it in the paper also. So they don't know that. They're trying to do something that they think is right. So I'm not arguing with anybody about that. But
Right.
it does create problems. Yes, it does.
I think that is a valid question that April brought up, a very important question. I mean, because I think that's quite applicable from a lot of we deal with a lot of obituaries because of the magazine, work in the magazine.
Yeah.
And do see cases like that, you know, and
Quite a bit. We see them too. Yeah, we see them. You know, but somehow we have to try to decipher that out. But like I said, we just have to sue them too, let them bring them in and find out. If we find out, we don't have to add them in as getting a part of the property. I mean, if they don't deserve it, they don't get it, you know.
Yeah. Absolutely, yeah.
Or make them testify on the oath and stuff. They might not know themselves really whether they're a true child, but try to get birth certificates or death certificates, affidavits. We have to deal with a lot of affidavits with people who know about these things. You know, we think they know about it. We hope they know about it. Yeah.
Well, Attorney McIver, we I don't know if we've exhausted all comments or whatever question from everybody, but surely what we've heard so far and the issues that you've addressed, I think has been quite very important to the community. A lot of people wants to know some of those same concerns and so forth. We have had from the McIver Graham Law Firm, your partner, Mr. George Graham.
Great lawyer.
Yeah. And it dispensed some very, very valuable information. We tried to get him back on again because he didn't finish up what we thought that everybody wanted to know. There were a lot of comments and so forth. So, well, you know, hopefully we'll get him back on another time. So,
yeah, get him back. Go ahead.
If he can find the time, he hasn't been finding the time yet recently. So, well, but anyway,
he's
he'll
a busy lawyer. He's deep into this land stuff too.
Yeah. And I'm glad to know that you all are busy. I mean, that's good for the community. So, April, do you want to share any more of the comments, or do y'all need any more?
That appears to be all of the comments and questions for tonight. Yeah. Other than Winston D. McIver Jr. says, I think I know this guy.
Yeah, he's in town? Is he in town?
I'll let y'all handle that offline.
I know it. I know he's here because Angela was in the office this morning.
That's why he's here.
Yeah.
Well, okay. All
Okay.
right. What was that other comment you got up there, April? It was Miss Vonda Cook.
Rhonda Vandross says that she is just grateful that her mom had her affairs in order because death can be devastating and also ugly when it comes to ownership.
That's correct. That's true.
Mm-hmm.
That's true. That's why it's best to do that if you can. Everybody can. Other state will tell you how your property should go, and you don't want that to happen if you can help it. Yeah.
All right. Wow. Like I said, we want to offer this as a series for dispensing legal information. Oh, by the way, this to our audience, this is information that you have to pay for if you're not on the Rural Community Magazine Live. Okay.
A little bit, yeah, a little bit.
Yeah.
We have a consultation fee where we can
touch
on stuff with people and determine whether they need to go deeper and file suits and all kind of stuff like that. Yeah.
Okay.
But there's a consultation fee generally somewhere in the neighborhood of $100, just to find out whether you got a case or claim or you need to do something else, you know. So don't. I mean, please get legal advice if you can, and
Absolutely.
I'm to everybody, you know, because there's so much fly by night stuff going on that you just don't know.
Okay. My regards to Mrs. McIver. Mrs.
She right here.
McIver.
That's my backbone.
At least your technical backbone. I know your technical
That's
backbone.
my backbone.
Sweet.
Plus my cook. I can't make her mad. She cooked that fish and red rice.
All right, Miss Mac.
Yeah. Well, I've enjoyed it. If you know, later on, if you want me to come back for something, you know, we can keep going, because we just touching on stuff. This field is so wide and so big, you know.
Yeah, absolutely.
You know,
And
there's no need of going without understanding, at least get basic understandings about things, you know, that come up.
Well, these comments from Junior.
What's he talking about now?
He said we're about to get you in trouble, is what he's saying, basically.
How is that, son? How is that? I got my wife here with me. Tell his mama here with me. What? Okay.
Well, we have certainly enjoyed. Yes, we've certainly enjoyed having you on the show tonight. Thank you so much, Attorney McIver. We really appreciate it.
If you finish, you have everything. You finished?
Yeah.
Yes, sir.
Absolutely.
We're good to go.
Okay.
Thank you. All right.
Thank you so much.
Thank y'all for having me.
Well, until the next time.
Okay. All right. Thank y'all for having me.
Yeah. Godspeed.
So, Brother Edward, yes, that was a great show. Thank you all for posting your comments and questions for Attorney McIver. Just want to let you know that next week we will have Marilyn Hemingway and possibly a special guest with the Gullah Geechee Chamber of Commerce. They've partnered with the Sustainability Institute to engage the community, in particular Santee Cooper customers, in a discussion about the Energy Assistance Program. It's a great way and a great opportunity for about 150 homes to get an energy audit and a package to help save residential energy costs. And she wants to come on and talk a little bit more about it. One level includes 5 households across Horry, Georgetown, and Berkeley counties to get an upgraded HVAC system with ductwork. So, there's a lot of, there's many benefits to a program like this to basically weatherize your home and to get it to a place where your energy bills are lowered because of this free weatherization. And so you can find out if your home is eligible, and you can also find out the benefits of this type of a program, who can be approved, and some of the other benefits and factors that go along with it. So we will have Marilyn Hemingway of the Gullah Geechee Chamber on the show next week to talk about this brand new Sustainability Institute program. And so that'll be 7 p.m. Next Tuesday as well. So thank you all for joining us. We really do appreciate it. And of course, as you know, the broadcasts are posted on wcmagazine.net for a week after the broadcast. So please make sure you direct people to the website to take a look at this broadcast. And also they can go to our YouTube page where all of the broadcasts are, I guess you could say, where they all live once we've gone live. And you can always go back and see some of the great shows and topics that have been discussed. But again, we'd like to thank all of you for tuning in tonight and for joining us. It really Was great having Attorney McIver on the show, and we do appreciate all the support that he received tonight to, help us get through the show. So thank you all, and have a great rest of your week.
Absolutely. Godspeed.
All right.
See you all next week.
Yes, take care.
Thank you for watching the World Community Magazine's Hour of Power Live on Facebook.